Amendment of bylaws. Who can amend the bylaws of a corporation? Well, either the directors or the shareholders are able to do that, but when they are in conflict, it is the shareholders who generally control. We talked about pre-incorporation contracts and post-incorporation contracts, and so let's talk about promoter. We know that a promoter is an individual acting on behalf of a corporation before it is formed. He gets the financing together, tries to come up with office space, get the personnel lined up, all of those things. The person acting on behalf of the corporation before it is formed is the promoter. So let's talk about contracts which may involve a promoter and what are those liabilities of the promoter. Let's talk about a pre-incorporation contract, which started us off on our case law in the corporation section. A corporation is not liable on a pre-incorporation contract until it does what? Not ratifies it, until it adopts it. Remember that fine line distinction between ratification and adoption that I told you, that even our Court of Appeals, Supreme Court will use those words interchangeably. But for purposes of exams and bar exams, if you are not a corporation, you can't ratify something that occurred before you were formed. You can only adopt something that occurred before you were formed. A non-existent person cannot be a party to a contract. A non-existent corporation cannot be a party to a contract. If the corporation adopts the contract, then the corporation is liable. The question most often on a bar exam question is not whether or not the corporation is liable on a pre-incorporation contract, because it's easy. Did they adopt it or not? The question usually is the promoter liable on the pre-incorporation contract? And generally, the promoter remains liable on a pre-incorporation contract until there has been a what? A novation, an agreement of the promoter, the corporation, and the other contracting parties that the corporation will replace the promoter with the corporation under the contract once the contract adopts it. Now, it doesn't mean the promoter has to be liable. We had cases where it said, well, it depends on the intent of the parties. If the intent of the parties that the promoter not be liable and only the corporation once it adopts it, then the promoter won't be liable. What's the intent of the parties and was it clear? But quite frankly, why would you ever enter into a contract where you don't have somebody on the hook? So generally, the promoter remains liable, but it doesn't have to. And once the corporation adopts it, the promoter stays liable. If they were liable before, they're still liable once the corporation adopts it. Now they got two people on the hook, the person and the entity. And they will only remove the promoter once there is a novation. That novation can come after the corporation adopts, or it could be, and most likely always is, in the contract that says, in a novation clause, once the corporation adopts this contract, then the promoter is excused and relieved of liability. So how does a corporation adopt a pre-incorporation contract? Well, they expressly do it, they formally do it, they vote on it and do it. That's the easy way, and never the bar exam way. Or they impliedly adopt it. You know, unjust enrichment. They start using the space, they accept the benefit, they do all of those things. The promoter has to be very careful about his actions in pre-incorporation contracts, in pre-incorporation circumstances, because the promoter has a fiduciary duty to the corporation. There is something called the secret profit rule. Since the promoter is a fiduciary, he cannot make a secret profit in his dealings with the corporation. And there are two distinct rules regarding that, and that's where dates become very important. So dates would only be on my test if the date distinction is imperative to answer the question. And so if you are a promoter and you do something like you buy a piece of property before you become a promoter and then you sell it to the corporation and you make a profit, that's okay. There's no secret profit rule. You didn't have a duty when you bought the property. But if you are already the promoter, you buy a piece of property yourself and then turn around and sell it as a profit to the corporation, all happening after you were the promoter, then any profit you make on that, you've got to disgorge, give to the corporation. Unless what? Well, unless the profit was known by the corporation, there's full disclosure, and everybody approved it, then there's no liability. So you have to distinguish on a test between whether or not it's a before or after acquired contract or circumstance that creates the profit for the promoter to determine if liability to the corporation is at issue. And then you have to look, is there anything in the fact pattern that would demonstrate that the corporation knew it, it was fully disclosed, and it was okay and approved. Absent those facts, then you're going to find liability for anything that the promoter personally profited for actions that he or she took after he or she became a promoter. Whew. We talked about the distinctions between a foreign and a domestic corporation. Foreign doesn't necessarily mean they're from a different country. It just means that it is a corporation formed and organized in a state other than Tennessee, but they are still practicing transacting business in the state of Tennessee. If it is a foreign corporation doing business in Tennessee, then that foreign corporation must qualify, register with the state of Tennessee. You know, I want to just say this briefly. If you're dealing with true foreign corporations, and by that I mean like foreign as in other countries, don't forget you may be dealing with the Hague Convention. It's tough. I've done maybe 2 cases with the Hague Convention total, one a personal injury case and one a family law case. Just put that in your little tickler, Hague Convention. If you're dealing outside the United States, you'll probably find that in play. All right. What is transacting business? When it says it is a foreign corporation is one chartered in another state transacting business within the state of Tennessee. Well, it's really not defined very well anywhere, but what we do have are exceptions of what is not transacting business. And that would just be like an isolated transaction. A continuum of business would be transacting business. When a foreign corporation is transacting business within the state of Tennessee and wants to qualify with the state of Tennessee, then they're going to simply fill out the document, the application that they can find on the website that requires certain information for them to qualify, and they're going to they're going to file it with the state of Tennessee, and we know that it is going to have the registered agent for service of process. What happens if a foreign corporation who is transacting business, a continuum of business inside of the state of Tennessee, is doing the business, but they are not properly qualifying with the state of Tennessee? Well, here are the consequences. They cannot prosecute a lawsuit until it cures the qualifying defect. So they can't bring an action, but it's simple. They're just going to go qualify, and then they can bring the action. And they are subject to a dollar penalty up to treble damages of taxes, etc., that they would have had to pay. But quite frankly, it's pretty lax. The contracts of a foreign corporation transacting business in the state of Tennessee without qualifying are valid. They're not void, they're not voidable, they're valid. We talked about issuance of stock, and that, of course, we know is when a corporation sells or trades its own stock. You know, if ABC Corporation sells 10,000 shares of stock to Biff, then that is issuance. But if I sell $10,000 of my personal stock to Biff, that is not issuance. The distinction is the corporation selling or trading its own stock. That's the definition of issuance. We also have some more dates here to kind of play with pre-incorporation and post-incorporation stock subscriptions. And these subscriptions are written offers to buy stock from a corporation. The big one that's hard to grasp is pre-incorporation stock subscriptions. And on these, it's when a corporation is not yet formed, ergo pre-incorporation stock subscription. And let's say that I do, excuse the phone, we're going to hope that stops in a moment. Let's say that I do a pre-incorporation stock subscription on a corporation that is not yet formed. And I do that, say, 4 months before the corporation is formed, and yet the corporation has not yet accepted it. Well, we know the corporation can't accept it yet because the corporation's not yet formed. When it's formed, what's the corporation going to do? Adopt it. And it is for that reason that the statute says that for pre-incorporation subscriptions, they are irrevocable for 6 months. Irrevocable for 6 months unless the subscription in writing provides otherwise. So if I do a pre-incorporation subscription, it's irrevocable, even if the corporation hasn't accepted it. A little different from our contract law in first year. This is a statutory difference because the corporation needs to be able to rely on that money to spring into existence. Conversely, a post-incorporation subscription follows what we learned in contracts law with no statutory exception. Until it is accepted by the corporation, it is revocable. And it's revocable in a post-subscription contract until it is accepted by the board of directors. So, stock by the corporation can be issued for any tangible or intangible property or benefit to the corporation. Cash, promissory notes, release of claims, contracts for future services. All of those are fine. The board must determine that whatever the consideration for those is, service, whatever, is adequate in order to get stock. We talked about terms like par, no par, and watered stock. Par, minimum issuance price. No par, there is no minimum issuance price. And watered stock is when there is an issuing of par stock for less than par value. And we talked about what's the liability for those if there is par stock. So if the corporation issues 10,000 shares of $3 par to Loretta for $22,000, can C recover that $8,000 from the directors? And the answer is yes, from those directors who knowingly authorized the below par issuance. Can they get it from Loretta who bought it? Yes. They can get it from the initial purchaser, even if Loretta didn't know of the water. And then if Loretta sells it to Garth, can we get it from Garth? And the answer is no, unless he knew of the water. Whew, hope you got all that. Preemptive rights is what shareholders have if there is voting stock. And the purpose of preemptive rights is for a shareholder to be able to maintain his or her percentage of control in a corporation. If there are preemptive rights, it needs to be conspicuously stated on the stock certificate, in the charter, etc. And this permits the holder of voting stock to maintain his percentage of ownership by buying stock first whenever there is new issuance of stock by the corporation. This can be done with cash. Let's do an example. If Mr. Majors owns 1,000 shares of C Corporation voting stock and there are 5,000 shares outstanding, well, then we can do some pretty simple math. Mr. Majors owns 1/5 or 20% of the corporation. Let's say that C Corporation is now planning to issue some new stock, and they're going to issue 3,000 new shares. If Mr. Majors has preemptive rights, then how many shares does he have the right to purchase? Keep his 20%? 20% of 1/5, he has the right to purchase 600 shares, 1/5 of 3,000 or 600 shares. Unless it is provided in the charter, there are no preemptive rights. I encourage you, like for the bar examination, you want to impress them. If it doesn't list that there are preemptive rights, then we know there's not any, but later on kind of answer that essay question in the alternative, and they'll be impressed by that. Shares issued within 6 months of a corporation don't have preemptive rights. We're not going to do preemptive rights to compensate officers or directors. And we're only going to do preemptive rights, and I think I snuck that in there in the definition I told you, but let's think preemptive rights, you're going to buy them with cash, not services, etc. In a corporation, we need at least a minimum of 1 director. You can have a lot more than that. It can be by formula, it can be in the bylaws, it can be in the charter, but the number that you want, but you got to have at least 1. Sometimes the initial directors are either named in the charter or, as we said, they are voted on at an organizational meeting. We know that shareholders have to have a meeting every year, and shareholders may remove directors with or without cause unless the charter says they must be removed with cause. The board of directors, their role is to manage the business of the corporation and select and supervise whoever are the officers, and they also are the ones to declare a dividend. Remember, in any fact pattern, that an individual could actually be wearing every hat. An individual could be a director, an individual could be an officer, an individual could be a shareholder. So when you're looking at a fact pattern, you want to be asking yourself what law applies to these facts: director law, shareholder law, or officer law, and be careful. The directors have a duty of care in Tennessee that they are going to function in what she believes is in the best interest, good faith, to be in the best interest of the corporation with the care of an ordinarily prudent person in a like circumstance. We talked about a subjective intent and an objective intent. subjective, what the director thinks in his or her own mind. Objective is the care of the ordinarily reasonably prudent person in a like circumstance. We talked about the definitions of nonfeasance and misfeasance. Nonfeasance, you have a duty to do something, you do nothing. I'm a director, I'm drunk all the time, I just enjoy the money from the corporation, I don't show up, I don't vote. Nonfeasance. Misfeasance, I'm there and I have violated either the subjective or the objective duties that I have, and I am personally liable for misfeasance. However, remember that a director has the right to rely upon reports of certain officers, accountants, attorneys, unless there's a reason to believe those reports are not reliable. Directors, those are the duties of care of the directors, but we also know directors have a duty of loyalty to the corporation. We talked about the duty of loyalty, but most of the time in corporations, this comes up on fact patterns with interested director transactions, or those transactions where the director has a personal benefit in. And so we've learned that they are not void. They might be voidable, but we have talked about the safe harbor rule, where a director can actually do something that is in his own personal best interest, so long as it passes the legal criteria and the duty of care, duty of loyalty under the safe harbor rule. And these are ors, not ands. The burden shifts to the interested director to prove that it was either fair or reasonable, or disclose the conflict and it's approved by the disinterested board, or disclose the conflict and it's approved by the disinterested shareholders. Most likely one on a bar exam would be, of course, that first one, which is it fair and reasonable to the corporation, that burden being shifted to the interested director. Directors cannot, under their duty of loyalty, be on the boards of two competing corporations. Remember when we had that last case tonight where it had the hospital and they had some of the same directors? It was okay because they weren't competing. But in certain instances, if you're on the board of one corporation, you can't be on the board of a similar like corporation that is competing. You can be, if it's clear that they don't do anything near the same, it's perfectly fine to be the director on more than one board. Director can also find themselves in trouble for breaching corporate opportunity. You know, a director could do a self-interested deal for himself and the corporation be left out of the opportunity to do that deal. That's called what? That's right, usurping a corporate opportunity. And sometimes the defense is, but the corporation couldn't do it. It was impossible for them to do it. They didn't have the money to do it, etc., etc., etc. But the duty of loyalty involves the director not usurping a corporate opportunity. It's always wisest to disclose and get permission, but if you don't and you find yourself being sued, then the defense is they had the impossibility of performance, so I could not have usurped. Director liability could also mean that if you voted for an ultra-virus act and it cost money to the corporation, or a director is liable for improperly distributing dividends, knowing that the corporation would go belly under because they didn't have the surplus to do it, or if you are involved in those. Those are two common things. But the general rule is, as a director, you have presumed to concur with an improper distribution or an ultra-vires act unless you object to it, you dissent to it in the minutes, and you provide written dissension. Exception would be absent directors are not deemed to have concurred. Now, they might be liable for a breach of duty of care for not showing up to vote, nonfeasance, but they're not deemed to have concurred if they're absent. Or, of course, what we already said, if they relied in good faith on some documents, etc., attorneys, CPAs, you name it. Don't forget that officers are agents of a corporation, and so all of our agency law would still apply with officers functioning as agents of a corporation, including actual authority, apparent or ostensible authority, inherent powers of office, etc. I won't go over that. We had that on the midterm, but it's still in play here. We got to have at least one officer to prepare the minutes of the corporation, and that's the only officer that is generally required, although most have more. You've got to have a secretary, whether you call it a secretary or not, somebody to record the minutes. You know, the shareholders can remove a director with or without cause, and if a director has a contract, they can still be removed. But the director could have perhaps a case for a breach of contract. And then we talked about attorney's fees and things of that nature, which are statutorily permitted in certain types of cases if you win or if you lose. Shareholders are generally not liable for the debts of the corporation. The exception might be that watered stock that we covered before. If you sell your own stock after an issuance for less than par value and you sell it to another for less than par value. And another one would be, of course, piercing the corporate veil under the alter ego theory, and those would be with the Allen factors. Undercapitalization that we've talked about, it's usually not enough by itself and considered an Allen factor, but undercapitalization by itself is usually not enough to pierce. Mere domination, we talked about mere control, is not enough to pierce the corporate veil. It's usually looking at the totality of circumstances under the 11 Allen factors. Shareholders can take a role in the management of the corporation without having any issue there. Derivative action suits are a shareholder suing to enforce the corporation's cause of action. It's not their own corporation. Always ask in a derivative action suit who's going to get the funds, and if it goes to the corporation, it's most likely a derivative action. Now, you can have a derivative action suit that's also a direct action suit, but, you know, on a test, they got to kind of be clear enough to make a distinction, because otherwise you can't pick on a multi-state question. Mine will be clear. Generally, a recovery of any successful derivative action suit goes to the corporation. If you are a successful shareholder on your derivative action suit, then you will get your attorney's fees and costs covered. If you're not, you won't. And in order to bring a derivative action suit, you have got to own the shares of stock at the time that the transaction occurred. You should make a written demand on the directors to get them to do that which you want them to do. And so they are either going to be doing a demand refused or a demand excused. Refused, I'm not going to sue. excused, you don't have to make the demand because it would be futile. Maybe the director stole money. Well, they're not going to sue themselves. Then you file the lawsuit. Once you file the lawsuit, then the directors might get together and try to research it, resolve it, but maybe the directors don't know whether that lawsuit is appropriate or not, even if somebody stole money from the bank, or maybe they don't want it to get out to the public. So they can go to the court after you sue, after your demand refused or excused, after you sue, and motion the court to stay the derivative action suit until a special litigation committee can be appointed to investigate it. Then the court looks at the special litigation committee's makeup to ascertain whether their recommendation to go forward with the suit or not is appropriate. You're going to want to know what are some of the factors that the court is going to be looking at for a special litigation committee. And remember, we do not follow the Zapata rule that I think you did in one of the cases while I was gone. We don't follow that rule. Judges do not put in their own judgment on whether or not the decision by the directors was right or wrong, even if the judge disagrees with them. They only look at whether or not the special litigation committee or the director's decision was reasonable under the circumstances, even if the judge disagreed. So we do not follow Zapata. You know, the main thing that shareholders do is vote. So who gets to vote and to when? You know, we always have a record cutoff date in the records, and if the record cutoff date is in June and the annual meeting is set for July, and let's say the record date is June 6th and the annual meeting is on July the 6th, and the stock is sold on June the 25th. Well, who votes it? And the answer would be, well, whoever owned it on June the 6th. But if you sold it, you don't even want to show up to vote stock that you no longer own. So how do you get the new purchaser to be able to vote it? You do that by proxy. And we already know that a proxy is good for 11 months, 29 days. We do that in the statute because we got to have that corporate meeting every year. It has to be in writing. It needs to be delivered to the secretary of the corporation. An exception to that record date and proxy is if somebody dies who is a shareholder, the executor of the estate is free to vote that. I said 11 months, 29 days. It's 11 months by statute. I guess I'm thinking criminal law. Sorry. If it goes over 11 months, there's an automatic revocation, and a proxy is revocable even though it says otherwise, unless it's coupled with an interest. If it's coupled with a monetary interest, then it's not revocable, except for during the time it says, because of that being coupled with an interest. We talked about voting rights, voting trusts, voting agreements, and we know that a trust, by its very nature, means that the certificates are actually going to be turned over title to the trustee in trust. And so a voting trust is a little more formal. It requires a written trust agreement that you give a copy of that trust agreement to the corporation. The legal title of the trusts of shares are actually given to the voting trustee, and the other rights are retained by the shareholders. Just the voting right goes to the voting trustee, and those are valid for a maximum of 10 years, much more formal. More informal is a voting agreement. There's no transfer of title. There's no need to file with the corporation. There's no 10-year requirement limit as there is in a voting trust. It's just that there's an agreement, and they are enforceable by specific performance under our current laws. There's an annual meeting usually, but the failure to do an annual meeting really doesn't affect corporate statusness, but you sometimes get, like in many of our cases, this deadlock when you have two 50% shareholders, it's hard to do. You can't force somebody to come to an annual meeting. There's no way to specifically make somebody show up at an annual meeting. You do have to give proper notice of meetings, especially special meetings. If you don't give proper notice for both annual and special meetings, which included time and place, and then for the special meeting, the addition of what's so special about it, what is the purpose for which it is being called. If you fail to give that proper notice, the actions taken at those meetings are, get this, void, unless, of course, the person failing to receive the notice waives the defect. And that's why you get tons of things in the mail about shareholder meetings all the time. So, how do shareholders vote? Well, usually the meeting requires a quorum of those shares being represented at the meeting. And remember, we're talking about shares, not shareholders. And normally a majority vote is required. So if there's 120,000 outstanding shares, how many shares is required to make a quorum? Right, 60,001. So sometimes, however, you can have what's called a supermajority quorum, and it may outline that certain things require a greater percentage of shares to be present. It could, 90% of those to be present. If you have 120,000 outstanding shares and the requirement of 60,001 shares to be present, but let's say that you met the quorum of 60,001, let's say 62,000 shares are represented at the meeting, but only 50,000 of them choose to vote. The other 12,000 abstain. How many of the 50,000 have to vote for a particular proposal? Well, 25,001. Now that's true on most things. We're going to talk a moment about amendments to the charter.